All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Florida Bar versus Malik Leigh, case number 2023-0518.
May it please the court. My name is Mark Mason, and I represent the Florida Bar in this disciplinary proceeding against the respondent Malik Leigh. The bar filed a 6-count complaint regarding 24 rule violations involving a 3-year pattern of ongoing misconduct. This occurred in employment discrimination cases filed in federal court in the Southern District, and also occurred in circuit court litigation involving the living conditions of an apartment complex and an attempted class action. Before this disciplinary proceeding, Mr. Leigh's misconduct had already been the subject of a protective order, not merely because he disparaged defendants, school officials on social media, calling them liars, calling them corrupt, saying that one would be jailed and that one was a racist. He then, 3 days before a scheduled deposition, posted on Instagram that after this upcoming round of depots, he, quote, would love to start a shooting campaign. Mr. Leigh's misconduct not only led to that protective order, which required depositions to be held in a secured location with armed officers present, it also resulted in a 2-year suspension order in federal court. Also regarding his recalcitrance in refusing to own up to the objectively threatening content of his post. His conduct also resulted in 4 sanction orders imposing monetary sanctions, which he hadn't paid at the time of the trial and the disciplinary proceeding. It resulted in a gag order, 3 contempt orders, not only for his repeated violations of that gag order, but also for failing to take CLEs to address the ongoing civility and professionalism problems he was exhibiting. And then there was also, yes.
Let me ask you a quick question. It seems like the actions that occurred in one instance, in the civil case, they happened in September 2016, 2017. And then the second case, that happened between 2018 and 2020. We're in 2024. Why did it take this long to reach the Supreme Court or any place else?
Well, part of it was the scope of the misconduct. Certainly, as he committed more and more violations, it added to the investigation and the time it took to complete that. What added on to that further was that his co-counsel was his law partner was actually co-counsel on all these cases, since the bar was also investigating her regarding her role, if any, in the misconduct at issue. Some of the later. Yes.
I'm sorry to cut you off. So the first referral to the Florida Bar occurred in 2017, right, by the federal court. And you're telling me from 2017 till 2023, it took that long for the Florida Bar to get through at least the initial conduct that generated the referral. Why did it take so long? I'm struggling to figure that out.
Yes, Your Honor, and I understand that this case could have been handled more promptly. And I certainly understand that from the reporter referee as well. What happened is that the bar started investigating these things and decided to file one formal complaint. In retrospect, with how long it took, should the bar have prosecuted on the earlier cases? Probably, yes. But we ended up doing a comprehensive 6-count complaint in 2023 for conduct that spanned from 2017 to 2020. So I understand if you take the earlier misconduct, you have 6 years between that and the bar's complaint. but this was ongoing for 3 years, and it did involve an extensive investigation, a 60-plus page formal complaint, and 1,600 pages of appendix that was just attached to the formal complaint alone. I'm not even talking about the trial exhibits yet.
But
So-
once the bar, filed the complaint, the process took, what, approximately 7 months?
6 to 7 months it took from formal complaint until the conclusion of the 6-day trial.
Okay.
He had been a lawyer, a member of the bar, beginning with the first case, the 2016, 2017 case, for only 5 years, correct?
Correct, 2011.
And
he
then
became lawyer.
when the second case occurred in 2018, he had been a member of the bar for 7 years at that time. So all this behavior, all these issues that were raised in this case happened during his early years. 'Cause I think he's like 49 years old.
Correct.
He's
at the-
admitted in 2011.
Yeah, at the time of trial, the reporter referee says he was 49 years old. As far as the inexperience goes, even if you would consider that a mitigating factor, that's all it is. It doesn't excuse the misconduct. And the nature of the violations we're talking about here were intentional violations of court orders. It was not.
But the inexperience might relate to making missteps, going down the wrong path. But when you're told you're going down the wrong path and you keep going and keep going and keep going, that's not just inexperience. That is incorrigible conduct. Am I wrong about that? I mean, that's basically the bar's position, isn't it?
That's exactly the bar's position, yes, Your Honor. And really we sought review for 3 reasons. Obviously the sanction is the primary one. But within that, there's 2 issues, is the referee's findings of not guilty on count 2, which had to do with the pretrial stipulation filed by opposing counsel. She input an electronic signature on it. There was some confusion as to which version was the correct one, but rather than call her up about it, he does a public filing that accuses her of criminal forgery. And then he follows it up by contacting law enforcement agencies to seek criminal charges against her. The referee found her, Mr. Leigh, not guilty on the 2 rule violations at issue in count 2, saying that it was an isolated instance of misconduct. The bar is asserting
Are you,
that. Yes.
yeah, and so that's the way you read the report? I mean, because the report is kind of incoherent on that. I mean, it says that at the top part, but then when it's going through the sanctions, it talks about having found violations on all the charges. So what are we to make of that?
Your Honor, I agree that the largest issue with the reporter referee is that it glosses over the underlying misconduct. You could read the reporter referee's counts 1 and counts 3 through 6, and you would have almost no idea what the misconduct involved. Count 2 contains the most amount of facts, and it still just talks about the different versions of a pretrial stipulation going back and forth, but it doesn't even mention the fact that he was contacting law enforcement agencies.
So are we supposed to be the ones making the findings then? Because it's hard to read that report as really having made findings. Are we supposed to be doing that now, or what?
Yes,
What's the
Your
posture
Honor.
of it?
I wouldn't argue for remand in this case because we submitted the court orders that firmly established the misconduct. I mean, all of the conduct that I described in my brief, I know just the statement of facts in my brief alone was 48 pages, but it's all derived from court orders that are final, that either weren't appealed or they were appealed unsuccessfully. All of the findings that are pertinent to determining the appropriate sanction are within those orders that I referenced in my opening. So with regard to count 2, it certainly wasn't an isolated instance of unprofessionalism. This wasn't just a single nasty email with what he did. This was a campaign to try and get her arrested, to try to paint her as some criminal. And that violated the 2 rules at issue, which was 4-8.4A and D, having to do with conduct prejudicial to the administration of justice. And it was humiliating and disparaging for the other attorney. And with regards to count 3 through 6, which was mostly focused on the circuit court litigation, the attempted class action, there's almost no findings whatsoever in the reporter referee. It just references what the bar's formal complaint charged. And on that issue, what the referee did is she attempted to recommend diversion on those counts. But the problem with that is the rule governing diversions after the submission of evidence says you can only do that when there's minor misconduct. This misconduct was not minor. I mean, even the referee, for all the omissions that may be within that report or referee, she's recommending a rehabilitative suspension. She recognized this conduct is not minor at all. Diversion is not appropriate, and you can't just separate the counts and isolate your review to say, well, this misconduct was minor even if this other misconduct wasn't.
What is the bar's recommendation? What are you asking us to do?
The bar is seeking disbarment for Mr. Leigh in this case. This is his first disciplinary proceeding, and I know generally speaking it's unusual to go straight from no discipline whatsoever to straight disbarment. But the reason the bar is asking for that is because of the 3-year pattern of intentionally violating court orders, especially in the class action litigation.
Can you address standard 6.2 in the context of this case? Disbarment when there's an intent to benefit and then harm and serious harm. Is that not kind of an assumption in this case? Why is that so clear from the record?
It's okay. The standard 6.2 deals with serious interference with the legal proceeding and knowing violations of court orders. And those were findings by the presiding judges and magistrates repeatedly in the court orders in which they sanctioned Mr. Leigh. They said that he offers these excuses and he attempts to confuse matters and just to rely on his ability to talk his way out of things, but he's not taking responsibility. I mean, we're talking 2023 complaint versus 2017 misconduct. I understand the delay issue, but at the same time, he's had all that time to complete CLEs, to even enter into payment plans to pay these sanction fees, and he didn't do it until the referee excoriated him at trial and said, you better do something. And then he comes back to the stand the next day and says, well, I just emailed opposing counsel and I inquired about getting on a payment plan. These were all steps that could have been taken earlier.
And I guess the distinction between suspension and a disbarment, I think, would be harm, right, to the client,
right.
Potential harm. And so why, I guess the argument is that the clients ended up getting a benefit from the proceeding. It took a while and it was despite this, but can you address the harm aspect specifically in terms of disbarment versus suspension?
In count 4, one of the sanction orders imposing monetary fees that was made payable by both Mr. Leigh and his clients, first off. And that was because he filed a frivolous motion for default that had absolutely no basis in fact or in law. It led to a completely unnecessary hearing. And these are, by his own words, extremely poor people. They cannot afford to be paying sanction fees for his misconduct, for his inability to understand fundamental legal principles. So there's that. There's also the fact that he's talking about these health concerns that are immediate, that justified immediate action. But this class action case just languished for 2 years, and he never got past filing a complaint that could survive a motion to dismiss. It did no benefit to his clients for him to just struggle to file a complaint without calling someone a slumlord like he was repeatedly told to do. So one of the cases I relied upon for disbarment is the Florida Bar v. Springer. It also involved a 6-count complaint. It also involved 28 rule violations versus 24 here. It involved a bar complaint that was filed in 2002 regarding conduct that was from 97 to 2000. But there was a pattern there, a lack of diligence, and then a dishonesty in trying to cover up the incompetence when clients were asking for status updates. And what this court said is the only appropriate sanction for this type of conduct is disbarment. And for that reason, I asked for disbarment. I'll save the rest of my time for rebuttal.
May it please the court, Juan Arias on behalf of Mr. Leigh. This case has always been about the degree of discipline to be imposed, even at the time of the final hearing. Mr. Leigh appeared at that hearing. 10 rule violations were found. 1 count was found as not proceeding. So 3 of those rules in count 2 were still found in other of the counts. But he went to that hearing acknowledging, apologetic, and more importantly, was able for the first time to tell his story, because this court, this high court, probably is asking, what was he thinking? in getting involved in these two litigations? Because that's exactly the first thing I asked when I got involved in this case. His personality traits are based on growing in a military family. He was a military brat, moving around. His father was absent in his military duties in the Air Force, enduring emotional and physical abuse by his mother, living in his home and family, leaving the home and family at a young age of 13, had devastating car accident that derailed his plan to be an athlete in Europe, rehabilitation and loss of reading skills as a result of that accident, circumstances of the murder of his girlfriend based on religion, the death of the mother of his young child, he's a father, and 2 heart attacks, all endured before he was 30. So the question that I've always had and that I pose to the court and I pose to this high court is, what do we do with individuals like Mr. Leigh who come with a baggage that will reflect?
So I had a
his
similar
conduct?
question. I guess the flip side of that same question, though, is what is our obligation to protect the public? And so why, if there's this continued pattern that's obviously negatively affecting the clients, should we take that into account more so than the impact to the public?
Justice Sasso, that's a great question, because these 2 cases I was involved in were pro bono. On the second case dealing with Stony Brook, nobody wanted to touch that case. In fact, there's evidence and testimony from a community organizer who is the one that approached Mr. Leigh because of the conditions of that location. So these were pro bono. Again, not excusing, but that is a fact in this case. So he jumped in, and his intent was to get the ball rolling, could get this case running, and then he could move out. He was not competent. The water was above his head. We know all of that. But he went in with a good heart, and absolutely was. The attorneys or the opposing attorneys on both cases ran circles around him. And that did affect emotionally how he responded to what was happening, the frustration. Again,
Counsel,
not an excuse.
I'm sorry to cut you off.
Yes, Justice
Talk to me
Francis.
about why Springer is not applicable to this case.
Springer is not applicable because of several reasons, Justice Francis. And that has to do with the fact that that case is about, above all, dishonesty. And above all, can be distinguished because it also deals with lack of diligence and communication. So you are affecting clients directly, and you're, in fact, in that case, to tell you how outrageous that case, the facts were, he falsified 24 certificates of title. I mean, this is massive, massive misconduct of this man.
The bar's position is that that case is directly applicable because, I mean, apart from the numerosity of the complaints and the allegations against that particular person, we have a similar circumstance here, and the referee did specifically find, did she not, that he engaged in some level of dishonesty when he had a court reporter, intervene and ask questions to a represented person without opposing counsel there. He was also sanctioned, and his clients also had to, were found also liable for the payment of those sanctioned orders. So why are those things not the same?
Well, they're not the same because the imperfect representation of Mr. Leigh in that second case, the Stony Brook case, was a mixture of not only incompetence but a overzealous effort to help these individuals because of their history and because of the history of the issues that have been already discussed before, the health, etc. So he didn't have a selfish motive on those, unlike on this case where you have an attorney who is practicing on the private side and trying to make money out of these cases. That was not the case here. So he is the one, Mr. Leigh is the one that disclosed that document. It was wrong, he took responsibility for that, and that is that. But the level of dishonesty on the Springer case and diligence is just another level. I think that the important part of this case today before this court is for the court to decide whether or not the standards apply to this case on the level of disbarment or on the level of suspension. And I would like to address the three standards because I know Justice Sasso had a question on it. And this is where we differ from the bar. We believe that this is a suspension case. Whether or not this is a 91-day suspension or 1 year or 2 years or 3 years, we believe that rehabilitation in this case is merited based on the background of this respondent, the type of cases he took without the competence but pro se with a good heart. I think those things are very important. If you look at
counsel, if we were in a posture where we were considering your client's admission to the bar ab initio, like he had just taken the bar exam, and this was the record before us, do you think we should admit him to the bar where he's posting things like he's posting online, things I can't repeat on the record here? It would seem to me like he would have a very uphill climb. And so I guess, fine, I mean, let's say we were, moved to suspend your client rather than disbar him. I can't imagine him being readmitted to the Florida bar with a record like this. So help me understand why. Am I seeing that wrong? Is this someone who you think represents the kind of person you would want to represent your family in a dispute? Why should we admit him to the bar?
just a Curiel, it just happens that I do that kind of cases, and I appear before the board 3-4 times a month. Keeps me busy. And the beauty of the rules of the FBBE is that you get to show rehabilitation, because this court has plenty of case law that says people can change and can evolve and can learn and can contribute, because by making mistakes, you learn empathy towards others too. So I would gladly and proudly represent somebody that shows to me that he or she gets it, and that she has been rehabilitated.
Where's the evidence in the record that he gets it?
He testified, the remorse is there, and the court acknowledged that. He didn't go and fight all of these rule violations. He explained exactly the circumstances behind those cases. We did not go into that investigative hearing to just poke holes at everything. It just happened that count 2, which was mentioned by bar counsel, was flawed. Because count 2, we were able to show for the first time, after years of Mr. Leigh being railroaded by stories that were not correct, we were able to set that record straight, because the opposing counsel in that case received an email at 5:53 p.m. with a signed stipulation. And that counsel did not open it, the secretary did not open that email, and they filed something else. But Mr. Leigh, because of his incompetence, had lost ground before that court. So instead of the opposing counsel the next day say, you know what, you're right. We didn't even open your email. Because that's what happened. And I got to inquire into that from the secretary and from the opposing counsel, because he was so weakened. Yes.
Let me ask you.
Justice Navarro.
Yeah, as you know, I'm from Palm Beach County. I'm from West Palm. I'm familiar with Stony Brook since I was a prosecutor and a public defender. Stony Brook's been around. It's been a source of trouble. And very poor people live there, are victimized by other people, and that development obviously needed someone to come in and do what your client did, help, offer their profession to help out. So I can understand that aspect, and obviously anyone would appreciate his effort to try to help out a very needy area. But here, and I've sat as a circuit judge in Palm Beach County for 13 years, and if I was to file a bar grievance for every lawyer who didn't follow my orders, I'd be testifying before the bar every day, because some lawyers just don't. But the question here, it seems to me, it's just, we're talking about the degree of the penalty that he's going to get here. And what his inability to follow court orders just out blatantly, and after being told and warned to follow the orders over and over again, is not your typical case where I order someone to provide better answers to interrogatories within 10 days and the person doesn't do it. And then they're back before me and have to decide what to do. It's beyond that. This is like something way, way out there. Why, I mean, and as Justice Sasso mentioned, we have, obviously we want to try and work with lawyers who kind of come off the rail and try to put them back on again so they can lead successful careers. But, I mean, we also have to consider these clients who walk into his office and they see that license with our picture of our Supreme Court on it, and they have every reason to assume that we say this guy's okay. They have no way of knowing about backgrounds and things like that. I mean, we do have that obligation to the public and to everyone else also to make sure that the lawyer they're hiring is someone who's not going to behave like this. Now, I see from mitigators here that he did not do this for his own benefit. Obviously, he was, and the result of perhaps incompetence. I mean, class action lawsuits are not easy, and it requires a certain degree of specialty to really know how to do them correctly. And he just had this inability to follow court orders for whatever reason. Why should this not, so we're talking about the degree of the penalty, why should he not be disbarred? Why?
Yeah. Justice LaVarga, there is evidence on the record that clients testify as to his professionalism in their case, and there is no evidence whatsoever that in the areas that he practices, which is family law and dependency, no issues. So these two particular litigations really rattled this individual, and I think that because of the nature of his personality, he just did not handle them properly. I want to address whether or not this is a disbarment of a suspension, and I'm going to address the three standards. The one on competence says that disbarment is recommended when the conduct demonstrates that the lawyer does not understand. We know that he's been practicing for many years in the particular areas that is qualified, and there are no issues. So that piece of does not understand in these two cases, the emotions and his passions got out of hand, and he has acknowledged that. So suspension is appropriate when a lawyer engages in an area of practice in which the lawyer lacks competence and causes injury or potential injury. Then the second one, and I'm running out of time, so 7.1 requires intent to obtain a benefit, and the last one deals with whether or not he obtained a benefit, and that is abuse of the legal process. So these are the disbarment. That's not what we have here. None of those requirements under these three particular standards apply in this case. This is clearly a suspension case.
You can take a minute to finish up if you want.
Thank you. So that's what I was saying. So if you look, these disbarment requirements require a little bit more. And we don't have the little bit more here because we don't have him trying to get any benefit. These were pro se cases, pro bono cases. Intent to obtain a benefit also under 7.1.1. So in conclusion, the standards tell us that this court is to review and consider 4 questions. 1, duties violated. The lawyer's mental state, I go back to his background. Where does that fit in this case? How does that background can help others in the future with a passion, with his big heart, because he has empathy, clearly. You can see it from all he endured in these cases where he felt that he was in the right. Incorrectly and perhaps incompetently, but you can't take that away. Where does that fit in these 4 questions? And then, of course, the actual injury caused by the lawyer and the existence of aggravating and mitigating. Then the comment tells us that you want to consider, and this is very important, the 3 objectives, which the referee clearly considered, 3 objectives of fairness to society to protect it, but not to deny the public the services of a qualified lawyer. The evidence is that outside these 2 cases where he was over his head, he is qualified, and we had testimony from clients. And there's no evidence that he has begun any misconduct in family law or dependency. Then number 2, judgment must be...
Counsel, sorry to interrupt you. 10 seconds and then
Okay, yes,
wrap it up.
Justice. Then the last one is not to deny the public of the service, encourage reformation or rehabilitation. I think there's plenty of space to rehabilitate him. Let him come back and try to rehabilitate and come back and petition. He has a lot to offer. He's come a long way. His background is just unique. This is a unique case. He may be an outlier, but it's a unique case. And I hope that this court recognizes that there is a lot of talent and passion and great service in the future, if given the opportunity. Thank you.
Thank you very much.
I've heard quite frequently that this is just an instance of 2 cases. This was an instance of 3 years of misconduct in his first 9 years as a lawyer. This can't be just separated out as, well, it was just 2 instances. 3 years this was ongoing. And, he was overzealous because he had a lot of passion and empathy. This court addressed that very recently in the Florida Bar v. Schwartz and said overzealousness is not some personality trait that you get to use as a chit to cash in when you're facing discipline. He had a duty to be competent, to be professional. He didn't do that. He didn't attempt to do it in the class action litigation. Anything that he accomplished outside of the litigation had nothing to do with his behavior in court. I heard a distinction that, well, the Springer case is distinguishable because it involved dishonesty. Justice Francis pointed out that he did do dishonest conduct with regard to the taking of that deposition. I would invite this court to review Exhibit 94, the bar's exhibits. It shows the text messages that went between Mr. Leigh and the court reporter that showed he knew very well he could not meet with this witness, this represented party. And so he was sending her in there with a list of questions, with documents illegally obtained, and then I heard them say, well, he publicly filed it, he disclosed it, and so that took care of that. Well, he publicly filed them, and the disqualification order addressing that conduct says he did that with the intent to try and disqualify his opposing counsel.
So do you, the counsel on the other side sort of characterize this as, to the extent that there's the sort of macro protection of the public in terms of sort of general deterrence, but in terms of this particular lawyer, is disbarment more of a punishment, or do you believe that it's more prospective protection of the public if that were to be the outcome here?
I think it's necessary to protect the public.
From him, or just from this sort of behavior in a sort of general deterrence kind of way?
To ensure his rehabilitation, certainly, because he didn't take any steps he needed to take to show rehabilitation in time of trial. For the public, because, we shouldn't be facing in the future another instance where he undertakes representation, gets passionate and apathetic again, and then when things go sideways, suddenly he's just blowing up at people and using his childhood to say, well, I'm just a passionate person, that's how I was raised. It needs to protect the court system because, for instance, these are just the court orders that address this misconduct. It'd be twice as big, but I printed it on both sides of the paper. It's a huge waste of court resources to deal with this type of misconduct. So, for all those reasons, I would ask this court to disbar him. And I'm not saying permanent disbarment. I'm not saying he's beyond the pale and he can't come back and reapply for 5 years. Disbar him, he can apply again in 5 years and try to show that he's been rehabilitated. Thank you, Your Honor.
Thank you. Okay, our next case is Doty versus State of Florida, number 2023-1123.
Good morning, and may it please the court, Chief Justice, Justices. My name is Teresa Hall, and I represent Mr. Wayne Doty, who is the petitioner in this case. We're here today before you because of a summarily denied post-conviction motion that was filed in October of 2022. Mr. Doty had been in a resentencing hearing from 2018 where he was sentenced unanimously to death for the killing of Mr. Xavier Rodriguez, who was a fellow inmate in the Florida State Prison. I'm going to only address a couple of the issues from our brief, although we do stand on our entirety of our brief. I also have asked to reserve 5 minutes for rebuttal. The first issue I want to discuss is, what are we asking for? The petitioner is asking that the trial court be remanded to allow us to have an evidentiary hearing on our issues. We believe we have made factual determinations that are in dispute and that should be vetted out in an evidentiary hearing. As the court well knows, an evidentiary hearing must be held when there is facially sufficient claims that require a factual determination from Owen versus State, and that any question as to whether a Rule 3851 movement has made a facially sufficient claim that needs factual determination, the court will presume that a hearing is necessary. In Mr. Doty's case, the trial court summarily denied every claim that was filed in the motion.
Well, now, isn't this an unusual 3.851 because the defendant represented himself? I mean, ordinarily, in these post-conviction proceedings, it's about ineffective assistance of counsel.
Yes.
And there are factual questions about whether counsel performed adequately and if there was prejudice resulting from any deficiency in the performance of counsel. We don't really have that here. Mr. Doty decided he was going to represent himself, and I know you want to argue about whether he should have been allowed to do that. But that's the way the table was set, and so that puts it in a little different category than the ordinary post-conviction case. Isn't that right?
I don't disagree with you at all, Justice Kennedy. It does put it in a unique position. It's unique to argue the positions and the claims that we've made. But because of the very first claim that I really want to get into is the fact that we don't believe Mr. Doty should have been allowed to represent himself at all under Indiana versus Edwards. It's unique in the fact that Indiana versus Edwards comes from my home court from Indiana. I was a law student when that case was going on. And so I'm quite familiar with the trial court's position when they took the stance to make Mr. Edwards have counsel. In Mr. Doty's case, the government has an interest in the integrity and the fairness of a trial. And that has been said over and over again, whether or not it's a pro se litigant or a client that has a lawyer. And to be able to do that, we have to make sure that people are represented. In this case, I'm not going to stand here and argue that there weren't Feretta inquiries and that the trial court found that he was competent to stand to represent himself. I'm saying that there was not enough mitigation done or not enough evaluation done to bring out all of the factors that would have caused Mr. Doty not to be able to represent himself. It's different than being a competent person to stand trial versus a competent person to represent himself. And this court has a great compelling interest in making sure that the trial is fair and that it is the just and proper outcome. That's why we all do this work. There needs to be a heightened reliability that's demanded by the 8th Amendment of the United States Constitution. Mr. Doty had severe mental illness and possible brain damage. I'll get to the brain damage portion in the second issue that I'm going to cover. But it's clear from the record, from both trials and from the experts, that he had mental illness. He was abused as a child, physically and emotionally. He was neglected. He did substance abuse and alcohol at an early age. He had behavioral problems beginning at the age of 12. Post-conviction counsel, while writing and developing the 3851, hired 2 different experts to evaluate Mr. Doty. Dr. Valerie McLean issued a report, and in our brief we talk about what she found, and that included that he had problems with decision making, problems with perceptual reasoning, that he had damage, possible damage to the front temporal lobe. All of this caused him to have a complete disadvantage of representing himself at trial. If you read the 2018 resentencing transcript, the jury selection process was hardly anything.
Am I right, though, that this was not raised on direct appeal?
You are correct. I don't believe it was raised on direct appeal.
So what do we do about that? Are you asking us to reverse our fairly well-settled case law that we should just look past that failure?
We believe because it's a substance due process violation that it's a fundamental error.
I'm sorry,
yes,
what's the fundamental error here?
That he was not afforded the right to counsel, so it violates the United States Constitution.
Well, he was afforded the right to counsel. That's what the purpose of the Feretta inquiry is, right? It's to determine that, and he waived it. And so I guess I'm missing what fundamental error you direct us to that causes us to look past the failure to preserve this on direct appeal.
Sure. Well, based on Indiana versus Edwards, we do believe that the court should have basically, because of the government's compelling interest, made him have a lawyer. Made him have a lawyer through the resentencing.
Is that our law?
Well, now,
that
if they had done that, wouldn't you be here arguing that his constitutional right to represent himself, and after he'd been determined to be competent, was compromised, and that, you know, so it's like it's the either way that goes, the state's going to have handled it incorrectly. I struggle to see any reason that anyone there would have thought that he did not meet the basic standard that he had to meet to represent himself. He wanted to do it, and he made that very clear. And you know, he is a person with agency, and and he did his thing, and actually I think he demonstrated that he could do certain things in the process. Am I missing something there?
No, I don't disagree that he performed to the best of what his ability is. But I would like to point out to the court the rule in our procedures, 3.112, that not just any lawyer can represent a death penalty client. We make them have qualifications. We make them be a lawyer for 5 years and to have all of this experience and training. So if we do that to make a lawyer who is...
So are you saying we ought to have a heightened standard for self-representation in death cases?
Yes, I am.
And you believe that's consistent with what the U.S. Supreme Court has instructed on these issues?
I do, under Indiana versus Edwards, I do. And that is my argument, Justice. And I know that even this court in Mr. Doty's direct appeal, and I know Justice Kennedy filed a dissent in it, in the fact that he wanted to get rid of his appellate counsel, and this court ruled that he couldn't. And that's because this court believed that he had a fundamental interest, the government had a fundamental interest in the appeals process. And so Mr. Doty was forced to have appellate counsel in his 2013 appeal. And again, I know Justice Kennedy had dissented in that, and basically I believe, and I'm sure I'll be corrected if I'm wrong, that if he made a knowing, intelligent, and voluntary waiver of appellate procedure or appellate counsel, that's what he should have. But this court ruled that he shouldn't have that. We also have...
Can we go back to the procedural bar for a second, though? Because you have this broad exception that you cited for substantive due process violations to procedural bars, and I think in support of that proposition, you cite a second DCA case.
Yes.
That refers to the rule, but to me, the rule does not say that. The rule says if it could have been brought, it should have been brought, period. So do you agree that if we follow that second DCA case and create a procedural bar exception for substantive due process violations, that would require a deviation from Florida Supreme Court precedent?
I believe that it could, let me see how to rephrase that. I believe that the Florida Supreme Court has at different times found that individuals should have lawyers. It was the Florida Supreme Court that found Mr. Doty should have appellate counsel. It is the Florida Supreme Court.
And I'm talking only about procedural bar. Because I think to get past, to Justice Coriel's question, to get past the procedural bar, because this could have been raised on direct appeal.
Right.
You're saying, well, the procedural bar doesn't apply because you've characterized it as a substantive due process violation. And my question is, our precedent, second DCA precedent aside, which is what was cited in the brief, if I recall correctly, our precedent does not have this carve-out for claims that should have been brought for substantive due process violations. That would eat up everything on post-conviction. So why, if we follow that second DCA case that's been cited for that proposition, would that not require us completely reworking Florida Supreme Court precedent on the sole issue of procedural bar, the substance of that issue aside?
I think because the Florida Constitution follows the United States Constitution, and because the United States Constitution has talked about fundamental rights and weighing Ferretta versus Indiana versus Edwards, I believe because of that, the Florida Supreme Court should be looking at their precedent and possibly looking at the evaluation from the second DCA, which was Johnson versus State. I believe that's the case that you're talking about. And that a substantive due process that leads to fundamental error should be able to be raised at any time. And I believe that there are some Florida Supreme Court cases that cite to that, not to the same language, but that does talk about fundamental error and that they can be raised. And I think that goes back to the very thing I started, and that is the fact that we're not asking this court to say, yeah, all of his claims are right, he gets a retrial. We're asking this court to afford Mr. Doty's opportunity to vet all of that out in an evidentiary hearing for the trial court to make an educated, informed decision. I believe the trial court didn't have all of the information it needed. And partly because Mr. Doty represented himself and he didn't bring out a lot of the things that he should have because he didn't know. It goes right back to 3.112. We don't let lawyers that have been lawyers for 2 years that have never tried a murder case, we don't let them represent death penalty clients. We didn't let Mr. Doty represent himself or waive his appeal in his direct appeal in 2013 because of the fundamental interest, the overarching goal of government is to make sure that the trial is fair. The second issue that I wanted to bring up also that ties into the first and the third is the fact that the trial court denied the ability to have a PET or an MRI scan. The expert that post-conviction counsel hired, Dr. McLean, as well as Dr. Michael Mayer, all agreed that for there to be full mitigation developed, a PET scan was needed. And the trial court denied the defense's ability. Now, what was interesting was at the trial court level, the state only opposed the PET scan because of the cost and the transportation and safety of getting Mr. Doty to a facility to do the PET scan. Well, I can tell you from Mr. Doty's health issues, he's been to that facility for health issues, and that's been able to be afforded. We've done it for other clients that we represent. So we are asking that the trial court be reversed on that issue and that we be allowed to have Mr. Doty have a PET scan and an MRI so that our experts can articulate to the trial judge exactly why the third issue, which is the failure to fully investigate mitigation, wasn't done. And that's because all of the information wasn't there. And so under Farrell, which is a Florida Supreme Court case, first we have to determine the defendant must establish a particularized need that the test is necessary for experts to make a more definitive determination. Both Dr. McLean wrote in her report and Dr. Mayer wrote in his affidavit that it was absolutely needed to be able to make a full evaluation. Mr. Doty didn't ask for that. I'm not sure that he would have been educated enough to ask for that. It'd be like asking a cancer patient to go to the hospital and say, I'm going to order my own PET scan because I want to see if I have cancer somewhere else. We would never do that. We would never expect a cancer patient to do that. Even if the cancer patient was a doctor, we wouldn't do that. And so we're asking that Mr. Doty be able to have the PET scan so that the post-conviction counsel can develop what mitigation there wasn't developed.
Well, but it just seems like to me what you're trying to do here is get around the fact that he decided to represent himself. And he put himself at something of a disadvantage because he decided to represent himself. You've made your first argument in the Indiana versus Edwards, but if you don't prevail on that, it just seems like the rest of this is all about trying to undo choices that he made and the consequence of choices that he made, and that's just not the way it works. I mean, when a defendant decides to represent himself, he's charted a course, and he's got agency and he's got rights, but then he's got to live with the choices he makes. And now we see this over and over again. I mean, this is not at all unique. And some might think it's just gaming the system because all these things lead to dragging it out longer. And you can self-represent yourself and then say, oh, I shouldn't have been able to, or I didn't get to do something that I should have done, or and then I get a do-over, and so that delays the execution of the sentence. But all that aside, it just seems like to me that this is all about trying to undo the consequences of the self-representation.
I wouldn't say it's trying to undo the consequences. I think our argument is that it wasn't completely voluntary knowingly because of his mental illness and his brain damage. Justices, I had started with 20 minutes. I wanted to reserve 5 minutes. I'm down to 3. So if there's not any other questions, I'd like to keep that 3 minutes for my rebuttal, if that's fine. Thank you.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Christina Pacheco, and I represent the state of Florida in this case. The post-conviction court properly summarily denied all of Doty's claims in this case because they were procedurally barred. They were also refuted by the record, and his ineffective assistance of counsel claim was insufficiently pled. With regard to the Ferretta inquiry, as counsel acknowledged, there was a very thorough Ferretta during the post-conviction hearings. Post-conviction counsel explained and acknowledged that it was extensive. And what's significant in this case is not only were the Ferretta hearings extensive before Judge Davis, he was the judge who handled Doty's resentencing post-Hearst, and he was also the post-conviction judge, so he had the benefit of seeing Doty represent himself pro se. But that was not Doty's first time representing himself pro se. He had his original sentencing, his original penalty phase, he represented himself pro se before Judge Nealon. When Judge Davis took over the case, he reviewed the records, he reviewed the first Ferretta inquiry, he talked with Judge Nealon, found that Doty represented himself adequately in court, professionally. There was never any issue with his presentation, that he was respectful, and the judge was very familiar with the record, and then still conducted another extensive hearing, made sure that Doty acknowledged the consequences of representing himself, that he would not be able to later then allege ineffective assistance of counsel. So this case is different in that there was the benefit of a prior hearing. Doty went full knowing the consequences of self-representation because he had done it before. And he did it well. He wrote his own motions. He acknowledged on the record that they were actually drafted by himself. He didn't accept the assistance of other inmates. He drafted his own motions. He made proper objections. He referred to the court appropriately. He was able to recall case law. He explained case law. He cited it correctly. He was a very savvy and knowledgeable pro se defendant. And what else I would like to point out is that the court was obligated to honor the defendant's right to represent himself, contrary to what my friend Ms. Hall has suggested. But in the record, there is Dr. Kropp's report, and Dr. Kropp found that the defendant had no severe mental illness that would preclude his right or preclude his ability to represent himself. So the suggestion that Doty was unable to make that decision is conclusively refuted in the record, because Dr. Kropp made this finding of no severe mental illness. And so it's our position that Indiana versus Edwards does not even apply in this case, given that there was no severe mental illness.
Can you address the argument that, had an evidentiary hearing been held, that these facts would have been able to have been developed, and that would be sufficient to refute the existing expert reports?
Yes, Your Honor. An evidentiary hearing was not necessary because there was no need for factual development, as I stated, because in the record there was evidence already that he had no severe mental illness. In terms of the imaging, the post-conviction court made findings that the suggestion that testing was required was actually refuted by the record. The court relayed the defendant's first post-conviction, or excuse me, the defendant's first penalty phase representation, his second penalty phase representation, his ability to testify in court, and also the defendant prior to the post-conviction proceedings. The defendant had testified in another inmate's case, Leo Boatman, before the court, and so that judge was also familiar with the defendant's ability to testify in that case, and found that the suggestion by Dr. McLean that this testing was required was actually refuted by the record, because Dr. McLean merely stated that the testing was necessary to complete her report because the defendant had low scores in, I believe, verbal presentation and memory recall, and the court said that that was refuted by the record. So there was no need for further presentation or a factual development on that claim when it was actually refuted by the record. And Dr. Mayer as well, the court found that his recommendation for testing was merely conclusory and not affirmative, in that it would confirm that he had some sort of brain damage. And so the court followed the proper analysis in a finding that there was no particularized need for the testing. And based on that, this court should find that there was no abuse of discretion there, because there was really no need, in fact, for factual development in this case.
But there's also the procedural bar issue on that
Yes.
point, right? Which, because everything you just said sort of acts as if it could have possibly been a live issue in the post-conviction at this point. But you're also, I mean, your main argument is that it's a procedural bar too, right?
Yes, Your Honor. All of his claims, with the exception of the ineffective assistance of counsel claim and the brain imaging claim, are procedurally barred. The ineffective assistance of counsel claim, I believe you already mentioned that during Ms. Hall's presentation. This court has long held that a defendant cannot represent himself and then later claim ineffective assistance of counsel, and same with standby counsel. So those claims are not legally sufficient claims, and the remaining claims are procedurally barred. All of them should have been raised on direct appeal and could have been raised on direct appeal, and this court has long recognized that a defendant's not entitled to a second appeal in post-conviction. And I think there's no reason the second DCA case is not on point. This court, to follow that, would be departing from its own longstanding precedent. But I do think that the facts are different from this case, and that it was a Giglio claim that the court found, even if it had been procedurally barred, it could have been raised still in the 3850 case. And that's not what we have here. As I pointed out, the Giglio claims here, they should have been raised on direct appeal, and they don't even meet the standard of Giglio. There's absolutely no indication that any statements here were conclusively false. And so there would be no, all of the claims are procedurally barred. If this court has no further questions, the state would respectfully request that this court affirm the lower court's denial of post-conviction relief, because no factual development is necessary here. Thank you.
Thank you.
Thank you. I believe it is true that the facts were not developed enough, and an evidentiary hearing should have been held. I don't believe the record is enough, based off of the investigation from post-conviction counsel, to refute the fact that Mr. Doty had mental illness. Dr. Kropp talked about it. Some of the non-statutory mitigating factors alluded to it. Witnesses testified to some of it. But a full development of any brain damage was not done, and that's because no one asked for a PET scan or an MRI, even at the trial level. The trial court appointed Dr. Kropp for the mitigation portion of the penalty phase. He's a psychologist. He's an expert in his field. We don't dispute that. But he's not a neuropsychologist, and he's not a neurologist. In 2018, it was common practice for individuals that had a history like Mr. Doty's to have a PET scan done. And it was to determine whether or not somebody had organic or some kind of permanent brain damage.
How do you respond to the state's argument that, you know, this is not the first time Mr. Doty has been down this road? He was in prison for another murder when he committed this murder, and that at the prior occasion, all of these issues were of record, and in this case, the judge had access to and thoughtfully considered that record in making the decision to allow him to represent himself. What's your answer to that?
Also in the fact that none of the mitigation that was determined in post-conviction was ever developed in the first trial either, in 2013. Again, Mr. Doty represented himself, and we don't agree, we believe it was inadequate. We don't believe he's qualified. And I always revert back to that rule about lawyers.
But at some point here, I think the point is that, he's performing. He is representing himself. And, he's not a lawyer, but, you've got an actual track record of having seen him more than once represent himself that the judge can look at and say, well, he's doing the basic things that someone representing himself needs to do. And so this is there. It's like these are facts that the judge has access to, and what you have is speculation.
Well, I think we have evidence to present if we were allowed. I do believe he represented himself to the best of his ability, but not to the best of the ability that should be afforded to somebody that's facing death. I know we always say death is different, and it is.
Well, was it your position that no one facing a death sentence should be allowed to represent himself?
It is my position that exactly, Justice Kennedy.
Okay, so now we have it. Now we have it. Now, how would we square that? I mean, someone who is a Rhodes Scholar, maybe not a lawyer, but a Rhodes Scholar and highly intelligent, you'd say, and no mental health problems. You say that person should not be allowed self-representation.
And the first thing that a trial judge says to somebody that wants to self-represent himself with those exact credentials is, you're a fool if you do it.
Well, yeah.
And you think that's consistent with what the United States Supreme Court has said?
I do under Indiana versus Edwards. Yes, Your Honor. Yes, sir.
Well, I think we read a different version of that case.
I agree.
I appreciate I appreciate that, sir.
Yeah, I think you're arguing for a change in the law. That's not the U.S. Supreme Court case law, and it's not our law. I mean, is that you're asking us to change the law on that?
I am asking in death penalty cases that individuals not represent themselves, especially if they have, in Mr. Doty's case, mental illness and likely brain damage. Yes. And with that, my time is up. I thank you very much for your attention to this matter. We are asking that this court remand back to the trial court to allow us to have an evidentiary hearing on the claims that we filed. Thank you, and please have a good day.
Thank you, you too. The court will be in recess for 10 minutes.
All rise. Florida Supreme Court is again in session. Please be seated.
Okay, our third and final case today is Kraft v. State of Florida, number 2023-1501.
Thank you, Justice Muniz. Alice Kopek on behalf of the appellant, Robert Earl Kraft. I believe I reserved 5 minutes for rebuttal. May it please the court, I feel a little odd right now because prior counsel kind of stole my introduction. Because as the court will probably realize that maybe not the issues aren't the same as the prior case that you had, but the posture and some of the, and just the circumstances are the same.
I won't repeat what I said. You've already heard it. So.
I won't repeat anything in those, well, like I said, for fear of being redundant, I will just say that we are here simply asking for an evidentiary hearing that we're presumptively entitled to. That is what the case law says.
And so on that, can you address, I mean, I think there's like a dispute over whether there's a factual dispute, right? So the argument is that regardless of this report that's been introduced on brain damage, there's no factual dispute because taking those facts as true, it can be reconciled with what happened in the trial proceedings and with the prior expert reports, and for that reason, there's no need for an evidentiary hearing. I think it seems like the briefs are talking past each other a little bit. It seems like your argument is that those facts need to be developed more, and the state's argument is, we'll take those facts as true. It doesn't make a difference.
And you're right, Your Honor, that's extremely perceptive. I would say we're not talking over each other, we're just disputing. And I would say that is, in some ways, to say that there are factual disputes. What we specifically alleged was that if Mr. Kraft had known that the discovery contained information that was relevant to him, that he would not have pled guilty.
Well, don't you think, though, that all, and I appreciate in your reply brief that you say that this all depends on Claim 1. So, I mean, don't we really need to nail down, you know, the issue of whether an additional, I guess the FREDA hearing should have been delayed for additional expert in order for the discovery issue to even be relevant?
Right, and that's why, principally why we shaped this claim as an IAC claim was because there was trial counsel, qualified trial counsel, who's been to numerous, I mean, it was in the record, numerous death is different, life over death, and is aware of mitigation, of red flag warnings, and such like that. And so what our argument is that when they were on, he was on notice, trial counsel, the court was on notice, the state was on notice when they got those competency evals from 1 hour of, because it really was one evaluation for 1.5 hours of Mr. Kraft by 2 doctors at the same time, 1.5 hours, no indication that they had any background material on Mr. Kraft. Dr. Blandino, I believe it was, said he did at least look at the DOC file, but there's no indication that the DOC file contains documents relative to childhood, relative to brain damage. So what we're alleging is that was a red flag symbol to say, hang on a second, he's making decisions that perhaps might be influenced. This was a serious car accident where he had a plate in his head, failed to follow up with a neurologist, and trial counsel, we believe the court also, but the trial counsel is certainly aware that brain damage of that type, a head injury of that type, can have lasting damage for the rest of your life. And what we're alleging is that then there should have been, well, this might create a problem. And then when you look at when the plea colloquy is going on, that you have indications in there of the brain damage of decision-making, irrational, impulsive, bad decision-making, is that Mr. Kraft was the one who brought up the discovery. This is a concern of his. He's saying, oh, I want to plead guilty, I want to die, give me death. And then he says, and it's on page 65 of the Ferretta change of plea hearing, where when the court says, are there any questions for counsel, Mr. Kraft, do you have any questions? And he specifically raises that He filed 2 motions, or he was planning to. He had talked to the state. One of them I don't need now because I'm putting in a plea of guilty, but I have one that I was going to submit a demand for discovery because I was sent some discovery, but from the index I can tell it's not all of it. So Mr. Kraft has this concern, and he's distinguishing, oh, this other one is essentially moot because I'm pleading guilty, but this other one I care about. And the state wants to seize on that. Well, he waived and he just said, it doesn't matter, I just want it from my records later. But it was the court who interjected that. That wasn't self-generating. Do you want to wait on taking your plea until after you receive that other discovery? Or you just want it for your own records later?
And so your argument is essentially based on that statement that trial counsel should have known we need to stop everything, regardless of these 2 expert reports that I have that says he's competent. We need to stop this. There must be brain damage there, and that's the only explanation that could account for that.
I don't know if you could say there must be brain damage there. You can say that there must be something wrong there. There must be something hasty there because Mr. Kraft just adopts the court. I want it for my own records later, Your Honor. Okay, for your own records for what? For future purposes? For something down the road? Well, we're sitting here, we're now in record purposes for future down the road. And as soon as Mr. Kraft got the discovery for his own records through our 3851, it was certainly instrumental to him to say that, well, if I would have known that, I wouldn't have pled guilty.
Didn't we find on direct appeal, though, that his plea was knowing, intelligent, and voluntary?
Yes, you did, Your Honor, but why I would say, and I know the state talks about law, the case doctrine, and I think the trial court even did, or the post-conviction court even did that in their order. What I would say is that this court, when it was doing the sufficiency and knowing, intelligent, and voluntary, had no indication of brain damage, the possibility of brain damage. Well,
yeah, but so the answer you just gave a minute ago to Justice Sasso was, I think, very candid in that it isn't necessarily evidence of brain damage that, you know, an individual says, I want this for my records, I still want to plead guilty. It might be evidence of poor judgment, it might be evidence of all sorts of things, but I don't know how the brain damage changes. First of all, I'm not sure it's in the record, and second of all, I don't know how that changes the analysis we performed on direct appeal. We've heard this before, we've decided it before.
Okay, first off, to answer the question, there was no indication in this court of what actually that discovery contained. Mr. Kraft didn't know what it contained, this court didn't know what it contained. So I would say those are change in circumstances that call into question the knowing, intelligent, and valid nature of his plea, that those were facts and circumstances that this court didn't have. And what I'm saying about, I'm not saying that it's necessarily evidence of brain damage, I'm saying it's a manifestation of brain damage, because his brain damage significantly is in the frontal lobe, which, forgive me, I'm not usually I can cite this stuff, but it's essentially your executive function, your decision-making capability, your impulsiveness. So what I'm saying is that it's a symptomology of, hang on a second, Mr. Kraft, you're filing a demand for discovery, you clearly care about discovery, but yet you don't want to see what's in it, and he hastily adopts I would say hastily, because at this point his mind is fixed on, I don't care about anything but I want death. And so what I would maintain is our courts, including this court, should give more significance to these gentlemen's rights and their lives than they do.
Okay, on that we certainly agree, but let's assume we get past the law of the case issues, let's assume we get past everything we've discussed so far. I'm not all that moved by what's in this discovery. Can we talk a little bit about how what's in the discovery would have changed anything at all about these proceedings?
Okay, well, the way that I laid it out, the way that I believe it's relevant and why I thought it perhaps might be significant to Mr. Kraft is that, as I alleged in the initial brief and we filed as an attachment to our 3851, was that a month after this happened, Mr. Kraft filed a grievance and he said, hey, I think y'all set me up. He's at Florida State Prison, but he says it was over at Columbia CI, but I think y'all set me up. And there's no indication in any of the record, or, or the evidence before Mr.
Let me ask it this way. What's the exculpatory evidence that you think appears in discovery?
Well, and I would say exculpatory. I mean, we raised on issue 2 an entrapment defense. I conceded that because the trial court said I wouldn't have, or the post-conviction court said I wouldn't have granted that I really couldn't, in good faith, argue this on a direct appeal. But it's certainly mitigating. And one reason why...
Wait, what's the mitigating evidence?
That you have a young man who is objectively, observably my client, in an agitated, hostile state. He's only in disciplinary confinement because he tried to harm another gentleman, inmate, who said, I'm afraid he's going to try and kill me. That's the only reason he's in disciplinary confinement.
What do you think that mitigates?
Well, and okay, let me put it as if I was a juror sitting and listening to mitigation, and the inmate prior said, they told me he was a sex offender and asked me to harm him, and when I refused to do it, they took me out and put Mr. Kraft in. And right there, you're like...
But they didn't say that to Mr. Kraft, did they? I mean, I've just struggled with this. What they supposedly, okay, supposedly said to some other inmate, that's over there. But Mr. Kraft is very clear. They didn't say anything like that to him, isn't he?
Well, no. And one thing I want to say is...
Well, what did they say? What does Mr. Kraft say? They said to Mr. Kraft.
And I want to preface this with saying Mr. Kraft, at the time he's making these statements, has every incentive to say what he needs to get death. What he said is, well,
that's his choice.
I told the sergeant, if you put me in a cell with anybody, I will kill them. And the sergeant says, I got somebody for you. And then Mr. Kraft says, now I'm not telling you that they told me to kill him. They always say that. What our argument is they don't have to. What we know objectively true is they placed him in a cell with a self-confessed child sexual predator who was supposed to be on protective management custody because, sadly, he telegraphed his death from the time he entered prison. So that is just objective evidence that you take a gentleman, he's in the care and custody and control of the Department of Corrections. He's in an agitated, perhaps homicidal state. They've got 11 beds open. This gentleman, the victim, is supposed to be in protective custody. This guy just tried to kill somebody. He's a child sexual predator. This court's, I'm sure, seen enough of these prison murder cases that that's the lowest of the lowest rung on the totem pole, and the victim knew it, and that's who they chose to place him in there with. And I would say that's mitigating. When we talk about, if a jury hears that, and also hears that Mr. Kraft is a child sex abuse victim, and we know that that conduct is so egregious, and the damage that it could do to children and society as a whole, that we have changed the law in the state of Florida to make it that we can execute people who have molested a child. That is the damage it does to them. And I'm not saying Department of Corrections knows that he was a child victim. I don't know that. What we do know is that he placed him in that cell with a self-confessed child sexual predator when they knew that Mr. Kraft, with 11 open beds, that they knew that he was in an agitated, volatile state. I would maintain that's mitigating.
Can we go back quickly, just to the ineffective assistance of counsel aspect? We have Brown versus State saying that defense counsel is entitled to rely on expert evaluations. There's 11th Circuit case, I believe the state cited saying the same proposition, that it's not ineffective assistance of counsel to rely here on 2 experts. How do we square this with an effective assistance of counsel framework?
All right,
Does it all turn on that, the discussion of discovery?
What I would argue is, number one, that these weren't experts that trial counsel retained. These were court-appointed experts for one referral question, and that was whether he was competent to proceed. As I indicated, there is no reference that they were given any documentation, that trial counsel said, hey, let me give you all this background material on Mr. Kraft. No indication in the records or their reports. As I said, Dr. Blandino said, he reviewed the DOC file. So that's what I would say. First off is he's not entitled to rely, or shouldn't be relying simply on a court-appointed expert that he didn't retain, and then in that expert report it had the significant brain injury that should have been the red flag. And then also I would say, again, this is a 1.5-hour meeting. Eval with Mr. Kraft is literally all the protective duty that one of the cases the state cites is Godinez, where they talk about the protective duty, the weightiness and responsibility of ensuring intelligence and voluntariness. And I would say a 1.5-hour evaluation with 2 experts to determine whether somebody's competent to proceed, who has an incentive to tell them whatever they want to hear, that will say he's competent and he should get death if he wants it. And I know I'm into my rebuttal time unless the court has any further questions.
May it please the court, Assistant Attorney General Charmaine Millsaps, representing the state. I'd like to clarify on issue 1, since that's what we've been talking about this morning. They're really 2 separate claims. One is a claim of ineffective assistance of counsel for not relating to the Ferretta hearing. And that's valid because before the Ferretta hearing, he was represented by the public defender. But everything having to do with the plea, by the time of the plea, Kraft is representing himself. So these have been tangled and they really need to be untangled. So I'd like to start with the one valid claim of ineffectiveness before you, which is whether the public defender who was representing Kraft.
You don't mean valid, you mean cognizable.
Yes, it's not cognizable. You cannot, Ferretta itself, the very case that established the right to represent yourself, put in a footnote that if he does so, we will not allow ineffectiveness claims. He cannot raise an ineffectiveness claim against himself. So by the time of the plea, he's representing himself, and that part's not cognizable. But the one regarding whether counsel should have known from the 2 expert reports. First, I do have one little, it's pretty clear that Dr. Blandino at least had access to Kraft's hospital records, because it's Dr. Blandino's report that talks about the accident and the follow-up of Kraft was in an accident when he was 13 or 14 in 2004, and that's in Dr. Blandino's report. So he is having access somehow to at least some background records of Kraft. But regarding that, counsel, whether it doesn't matter, when you say this court has said that counsel is not ineffective for relying on experts, and it's never been limited to defense experts. These are 2 court-appointed experts. I perfectly see maybe counsel shouldn't rely on the state's experts, but these are court-appointed experts. These are considered neutral, and there were 2 of them, and they did refer to that. But I'd also like to, so I have 2 reasons why counsel wasn't ineffective for not delaying the Ferretta hearing. First of all, the post-conviction court found there was no basis to do so. And I'd like to talk about that because that gets into Indiana versus Edwards. And then my second argument is these were two court-appointed counsel who did have at least some background somehow of craft, and they both found him competent. Now, regarding Indiana versus Edwards, it does not apply to pleas. And I would point, it's Godinez versus Moran that applies to pleas. And I would point out that Godinez was a capital case. Godinez, when the United States Supreme Court held that what you have to meet is the Dusky competency standard, period, to enter a plea, they were saying that in a capital case. Now, Moran, Godinez was out of Nevada. Nevada, there are penalty phases, like the penalty phase here. Their penalty phases are in front of 3 judge panels. So all of their penalty phases are bench penalty phases, but the bench penalty phase was a bench penalty phase too. So it doesn't, there's no distinction between capital and non-capital. Godinez was a capital case. Indiana versus Edwards and Rule 3.111 don't apply to pleas, and this was the plea. That's my answer on the plea. It's not involuntary. All he had to do was to be competent to represent himself and enter a plea, and that's what he was. And then, so in counsel, and this is what the post-conviction found. He found that there was no basis to delay the Ferretta hearing. That's why counsel wasn't ineffective. You cannot rely on Indiana versus Edwards or our rule because it's Godinez that applies. And there's no doubt, and opposing counsel even admitted that during the Huff hearing, that he was competent. So this lower standard of being hasty and all that, none of that matters. And then he was retired. And then there's also no prejudice regarding trial counsel's failure to attempt to delay the Ferretta hearing. He had no means of doing so, but there's also no prejudice because the defendant has a right. That's a personal right. Counsel cannot and has no duty or obligation to interfere with the defendant who wants to enter a guilty plea. That's a personal right of his. And the outcome would remain the same. None of any of this having to do with DOC and Sergeant Bell putting him in the same cell had anything to do with his stated on the record repeated reasons for entering a guilty plea. He wanted the privacy and privilege of being on death row. He did not want to spend his incarceration in the chaos, and that's a quote from him, of being in general population in prison. He talked about how dangerous it was, knifing, and it was just chaos. And so he wanted to be on death row. So none of anything you could do, although I would point out the post-conviction court agreed with you, Justice Correll. It didn't find anything mitigating about inmate bullet and all the information about who placed who where in a cell. But that's not cognizable. The only thing that's cognizable is the claim of ineffectiveness for not delaying.
How do you answer? I heard 2 answers to my question from opposing counsel, your opposing counsel. One was about whether it was exculpatory, and the other was about mitigation, presumably, I guess, under the CCP aggravator. I think she's closer. She's closer to having something on CCP. Can you respond to her argument that it was mitigation evidence in that there was sort of a suggestion that the victim had this coming, and this was a way for the defendant to sort of find favor with the personnel, and therefore perhaps that mitigates his actions as cold, calculated, and premeditated. Can you respond to that argument?
Certainly. First of all, that kind of evidence does not meet the definition. There's a constitutional definition of mitigation, and it has to do with the defendant's background, character, and record. And what the DOC guards, and I'm going to say this for purposes of accepting their facts as they are. Worst case scenario, whatever inmate Bullitt says about what they said to him, Kraft himself said they did not say those things to him. Okay, so there's a, I don't even think that'd be admissible.
It can't affect his state of mind. It's not, as a matter of relevance, it's not coming in because it doesn't reflect on whether he was calculated.
I don't even think that's admissible, Your Honor. I don't think that's relevant.
Right.
I don't, so it wouldn't even come in a penalty phase. It doesn't meet the definition. It's not relevant. It didn't have anything. It couldn't have affected his state of mind. He couldn't have been incentivized about something that, according to the facts as pled, he didn't even know about.
His background, he had beef with the victim beforehand, right? Did he know about the victim's background before being put in the same cell?
It doesn't say him before. They were in the cell together 2 days before the murder. And yes, they were fighting. And Kraft does assert that the victim told him that he was a child molester. But I very much, this court has never found a pretense for purposes of CCP.
No,
under the.
I just want to sort the arguments and sort of keep them.
Certainly, but this court would not consider that a pretext of justification based on the victim's being, even if he had proven that he was that.
Right.
But Kraft did assert that while they were in the cell together for those 2 years, 2 days, he was placed in the cell, and then 2 days later he murdered the victim. And he said the victim never attacked him. There was nothing like that. So that would not count as a pretext. This was in no way some sort of self-defense.
So back to your prejudice point, I didn't follow what you meant on that. The prejudice, you were saying that even if you got past the deficient performance prong, that there would still be no prejudice. Could you elaborate on that, because I didn't follow that?
On the prejudice prong, yes, I did. I supplemented with the case of Leigh, and these post hoc rational assertions that I would not have entered a guilty plea is not sufficient. So
okay, but so that's not on the issue of the ineffective assistance of counsel, though.
Well, there are two of them really before you. One I'm saying is not even cognizable. Everything having to do with the plea.
Okay.
He was
right. But on the prejudice thing, I just didn't understand if you were making a point about the first thing that you're saying is cognizable is, did counsel sufficiently investigate whether the FREDA hearing should have happened when it happened?
Because trial counsel was not counsel at that point. Okay. If anybody had a duty to investigate anything regarding with the inmate Bullitt, it was the defendant himself, because at that point he was representing himself. He should have said, no, I don't want to enter a plea. I want to get the discovery that would lead me to all this. Your Honor, the person who has a duty to investigate defenses and mitigation is the defendant himself when he is representing himself. Counsel is not counsel at that point. Counsel became standby counsel, but there's no such claim as ineffectiveness of standby counsel.
I understand that. So what was your prejudice point, though?
My prejudice point was on the first one that is cognizable.
Okay, so explain that. That's what I didn't understand.
Okay, well then let me explain it. He would have entered a plea anyway. The outcome would have been the same because his motivation for entering the plea was he wanted to be on death row. And this...
So you're saying even if he had not been allowed to represent himself, which is what the first part of this is about, right?
No, I'm saying if counsel had asked for the FREDA hearing to be deferred for some reason, which there isn't one, the defendant still would have entered a guilty plea because none of anything they're talking about, Indiana versus Edwards or experts or his mental state, none of that is his motivation. His motivation is he wants to be on death row.
I think the question I have, and what makes it cognizable? What is it that counsel did or did not do that makes the claim cognizable? The fact that he didn't ask for the Ferretta?
Sure, because at the time of before the Ferretta, counsel is representing him. Trial counsel, Assistant Public Defender Mashburn, is counsel. So he can argue things like, so that's a cognizable claim because he has counsel. You have to have counsel to do ineffective assistance of counsel. Okay. And by the time of the plea, he's representing himself. He hasn't got counsel. So he cannot do anything related to the plea. So the Ferretta is I don't think it's viable in the sense that it has any legs. It's a meritless one, but that is a cognizable claim. Everything having to do with the plea, he's representing himself. And since we've recognized the right to represent yourself, literally in the opinion where the United States Supreme Court recognized that, they said there is no such thing as ineffective assistance of pro se defendants. So I separate them very much.
Don't you think that they're really arguing not that they were ineffective for not delaying the Ferretta, but that they were ineffective for not delaying to further research the mental health damage that could have been there, correct?
Yes. So that claim regarding the mental health.
And so why do you think there's no prejudice to that?
Because his motivation, the defendant himself didn't even want this delayed, okay? And he has a personal right. So counsel couldn't have trumped that personal right, number one. Kraft could still enter a guilty plea even if his counsel tried to say to the trial court, I want to hire a third expert. And even if that had been granted, the defendant could still enter a guilty plea. And what I'm saying is, given his motivation, that's exactly what he would have done.
Right, but I mean, we're asking because, look, your argument on the performance prong is strong. We're asking because it seems like the precedent that you would be asking us to set, if we then say, oh, and by the way, there's no prejudice, we're having to make like these 3-level down sort of speculative assumptions about even if there had been more investigation and even if maybe he couldn't have represented himself, you know, and then he's got a lawyer and he still pleads guilty anyway. Like, why would we? That just seems like that would be an unwise thing for us. So that's why I didn't understand why you were even making a
No, I was
prejudice
just
argument.
trying to be thorough. Your Honor, you can certainly stop with the no deficient performance.
Well, and why on the prejudice aspect would it not be relevant that it was considered on direct appeal? I mean, the competency to enter the Friday, I guess it wasn't presented in terms of delay, so it would be different. But it would seem that because the court considered the issue on direct appeal, it seems like that would be relevant to prejudice.
Yes, I mean, you did have both experts report in the record when you were on direct appeal, when you found that the plea was voluntary. But the other thing that I have a problem, I've got a Ruiz problem with this kind of argument. Your Honor, he doesn't have to have complete knowledge for his plea to be voluntary. Under United States versus Ruiz, that you find out new facts after the fact, unless that amounts to actual factual innocence, the United States Supreme Court has directly held you do not have to have complete knowledge of all the relevant facts for your plea to be voluntary. A plea is voluntary under the law as it exists at the time and under the facts as you know them at the time. And there's no possibility here of actual factual innocence. So no, his plea, just abstractly, his plea was not involuntary. Even if you look at inmate bullet and all that, he doesn't have to know all that for his plea to be voluntary. And that he discovered it after the plea does not render his plea involuntary. And that's from the United States Supreme Court case of Ruiz, United States versus Ruiz. And if there are no further questions, we ask you to affirm the summary denial. Thank you.
Thanks.
Okay, I'm going to try not to speak too fast. But quickly, Justice Sasso, there was one other part of your question that I forgot to answer, and that when you're talking about qualified experts, the experts on these reports were not neuropsychology. They weren't experts in neuropsychology. So I want to, I mean, there's a question whether they were qualified at all on neuropsych testing or neurology anyway. When it comes to Edwards v. Arizona that the state is raising and says it's not applicable to guilty pleas, perhaps that might be true. Well, this is a capital case where the guilty plea didn't end it. Mr. Kraft had to represent himself in the penalty phase. And was he competent to represent himself or not? Who knows, because he didn't do anything. This is in contrast to the case that we just had where you were able to say, he objected, he filed motions. Mr. Kraft didn't do anything. His family showed up, he said, let them speak for conscience purposes. So the state has mentioned, well, his brain damage or mental illness, unless severe enough, doesn't make him incompetent. Well, we need an evidentiary hearing to determine. I mean, again, yeah, that's speculation. Well, it's not severe enough. We have no evidence of that because Mr. Kraft didn't develop it. The post-conviction court is saying, I'm not going to give you an opportunity to develop it. And Godinez, she says, I'm sorry, opposing counsel, Ms. Millsap says that they find competent to proceed as the Dusky standard, period, end of story. That's not what Godinez says. It says finding competent to proceed to trial is not all that's necessary before permitting a guilty plea pro se. The court must take another step and find out, is that waiver knowing, or no, actually, intelligent and voluntary. And so they say, in this sense, it's a heightened standard for guilty and pro se, but it isn't a heightened standard of competence, is what they say. And that, again, the protecting duty of the court imposes the serious and weighty responsibility on the trial judge of determining whether or not it's intelligent and a competent waiver. Ruiz has to do with impeachment information. It was in the government where they have a fax trap. They wanted the defendant to waive the ability to get impeaching Brady material, and they said it's hard to determine whether impeaching material is actually critical. So that they said that wasn't sufficient. That's not what we have. Perhaps people can disagree, but again, I maintain the fact this isn't your normal prison murder. We have a young man who was still going to be a young man when he got out of prison. This isn't our usual, he's a lifer. He wasn't facing the predicament of life or death in prison until the Department of Corrections put him in an agitated and volatile state into a cell with a child sex predator. He said a month later he thought he was set up. He knew at that point that he wrecked his life and all he had was life or death. And he made decisions that I maintain are a product of brain damage. Again, all we're asking for is that we respect his rights and his life more than he did and give an evidentiary hearing for him to be able to prove up these claims. I know my time is done. We would ask that you reverse and remand for that evidentiary hearing.
Thank you very much. We're adjourned.
All rise.